Don't be shy, don't stall, we got a funky vibe, yeah. Welcome all, it's a safe spot where the truth of mine. Share your thoughts, leave your worries behind. Woo! Defenseless, that's where you belong. Click that like and groove along. Hit subscribe, let the love flow free. Join the fam where you're meant to be. Woo! Got mysteries, stories that feel it right. We dig deep, ain't no secrets to hide. No judgment here, just an open crew. We're all about justice and the honest view. Yeah, defenseless, that's where you belong. Click that like and groove along. Hit subscribe, let the love flow free. Join the fam where you're meant to be.
Good morning, y'all. Sorry, I'm still just getting dressed. Putting my coat jacket on because it's a little bit chilly. And my arm got stuck halfway through. Afternoon. How are we? Are we good? Miss Teresia, you don't sound like you're particularly good. That doesn't sound very nice at all. Migraines suck ass. So surprise, I'm here. I was awake doing stuff. Good morning, Miss Louise. How are you doing? Okay. I think I'm decent. Enough-ish. Kinda. It's gonna have to do. Excuse me. Yes, I was awake doing stuff for the mock trial. So I thought I might as well just stream it. I'm here. But I've got a feeling that they do a couple of other hearings just prior to his. So, because I was watching it, I was stalking you in chat, Teresia. So I went into, thought, where would she be? If I was Teresia, where would I be right now? So I went into Hillbilly Crimes chat and went, I know my wench is in here, where you at? And no response. And then I went into Court TV, did the same, no response. Oh, my wench not there. But had she not had a migraine, that's where she'd have been. Oh, God. Now my washing machine's going off. All right. Without further ado, hello, Mr. Udev. How you doing? We're just starting. I'm not sure if his is the hearing that's first up. I think it might be a little bit way in. Oh, the judge isn't even in there yet. Okay. Cue it up properly, Jody, next time. There we go. Oh, that's just not right. Holy, what the hell do you call that? It looks like, Judge, I'm sorry. The comb over ain't working no more, love. Especially when the dome underneath is that polished. Oh, and his voice.
Jack still got cold.
Brings it out on behalf of the Commonwealth. Remember, Terry brought you on behalf of Sean.
Okay, Your Honor, Jeremy Bartley on behalf of the district staff.
All right, thank you. See Mr. Stines is present. The court set this matter today for the Stines hearing to address a few matters. I think we'll be in some position now when we'll be able to set.
Look at it. Look how shiny it is underneath. What the fuck? And then he's got those little swirly whiff bits at the back. Like, just shave it, Judge. Just. Oh, I'm going to have to stop that machine. Yeah. Do a no comb or just shave it. Yep, I'm gonna have to do the Fuck. Ah,
Contain value.
gotta go and do the washing machine.
Particularly in the long period in terms of.
I'm here. Oh, sorry.
Making reports findings that.
I'm having trouble sitting up straight. Sorry. My back's killing me.
A bond in this case.
I'll be back in a second. I'm just gonna sort this machine.
There's also some information in there that will go directly to some of the testimony that was given at grand jury.
All right, and Mr. Steele, how long, you don't have to make a response to that, pretty much, that, how long do you want to have?
Judge, you give us 10 days. I think we got it last week, so if you give us 10 days to respond to that motion. That's it.
All right, what I would like to do though is at least see how far we can get without addressing the indication PC evaluation issue. And the fact that the court hasn't read that, so if you can make mine, but we can address first, the motion to dismiss these vacant. Who's starting?
Your Honor, I will.
Okay.
Judge Royal Bath, Your Honor. Your Honor, we filed a motion to dismiss on 2001 under RCR 5.16. Failure to provide or to add a transcript of the grand jury proceedings. Court knows RCR 5.16 requires that the testimony taken in front of the grand jury must in fact be recorded. Now, we kind of came upon that surreptitiously. We were listening to listening to the grand jury tape, and there was a reference. Your Honor, I don't know if the court has made that grand jury, can I speak to the content of the grand jury aside from what I think?
Yeah, and the first right, the court has provided a transcript, CD recording of that which we used for.
Thank you. So there's a reference to one of the grand juries that said in our last meeting, or in our previous meeting, and I'm paraphrasing. And so at that point, we weren't aware of the previous grand jury hearing. And so I inquired with Commonwealth. They did respond to it. The response was basically, well, we met with them. The purpose was just to get a subpoena for medical records. And the judge, I just didn't have any response. But I guess, number one, what's odd about that to me is that I've been thousands of grand jury hearings, and if you want evidence brought to a grand jury, you usually subpoena after the hearing. I mean, there's no reason you don't have permission for the grand jury to subpoena. You send a subpoena, you subpoena a custodian to the hearing. And then the second piece of that that concerns me is that even if we presume that is what was going on, and I don't know, there's no recording, but if we presume that's what's going on, unless there was some sort of telepathic thing going on, there had to be statements made to the grand jury that said, hey, this is this case, this is what we know. And I think the Commonwealth was making a distinction that, well, if you don't come in and raise your right hand and swear, then it's not testimony. Well, actually, the distinction is it's sworn testimony, not sworn testimony. I'd submit to you that the only way you're asking for a subpoena and you're basing that on some sort of probable cause or evidentiary standard that you want the grand jury to consider, which is the only thing you're going to see. But you have to tell them something. They didn't walk into the grand jury room and say, just look at each other, and the grand jury said, hey, we'd like a correct subpoena. Now, I will say this, I do agree that Commonwealth can their legal advice to the grand jury, and the grand jury deliberations do not have to be transcribed. But whatever was said to the grand jury, if you don't do ask for or form their basis for asking for medical records, Judge, I think that should have been recorded, so we would have that available. And I think 526 requires it, and the remedy is that point shall form a motion to dismiss. I can address the other area, Judge. Okay. And the second area, Judge, I don't really think Canada, that may need an evidentiary hearing. It may not. I mean, I'm not sure. Well, I'll leave that to the Commonwealth as the response to that. But in terms of the other portion, yes, sir. As to the second portion of my motion, it's based upon Commonwealth feedback here. Mr. Cox actually handled Mr. Baker in that case. We all know the prosecutor's community is the aluminum back case. The detective goes in and testifies and says, basically, it was aluminum back used, this one used aluminum back. that testimony being misleading, the Supreme Court sent it back and said, look,
Yes, apparently that has been an issue on both feeds. The sound, sorry.
if you give evidence to the grand jury, you get misleading. And this, and, you know, the bigger debate really seems to be after that, is it, is it rise to prosecutorial? It's not
That doesn't help.
should stand the prejudice, or is it not? And to me, that falls without you representing the grand jury. And so when I look at the grand jury transcript, Judge, again, without getting into the case of PC report, one of the really things that one of the big things that bothered me was the grand jurors. First of all, they spent nearly half the time asking questions, and a large portion of those questions concerned the mental health issues. And the last question before the grand jury retires from deliberation was, so he was in the same mind as far as the investigation is going, and the answer is yes. That's Detective Stanford testifying. Now, first of all, probably not an appropriate thing for Mr. Stanford, Detective Stanford, to give an opinion on, but the rules of evidence, I get it. I mean, if there's an evidentiary issue, that's not what we're talking about. Here's the thing. If you're going to let a detective testify about sanity and render an opinion, that grand jury takes that to heart. He's seen all these facts, and I submit to you, without getting, I can't reference the report, but I'll say this. You're hard pressed to find much in the way of the investigation that would support the adverse. And so this is what I believe. I believe that had they not been told by a prosecutorial stamped witness, someone from the government, that he was sane, they wouldn't have got this case. Or at least they might not have got it on purpose. And so what I think, Judge, is that even if we're to find that this arises to level for this issue of dismissal prejudice, which is what we asked, at the very least, I think this thing should be remanded back and sent back to the grand jury and let them hear the correct that statement be corrected, or at least take it out. I mean, I don't think they have to put on evidence that's exculpatory for us. And I don't think that, you know, they can ask somebody to behind what an expert would say, even if it's a lay person. But if you do that, it can be wrong. That's a pretty risky thing. Here, the investigation, it definitely didn't show anything. There's other additional issues, Judge, and that's one of the things we won't have the evidentiary hearing for, is to ask about all these statements and what the detective had in terms of the investigation. We want to put that on to show why we believe that that was a mistake, in addition to anything else.
And if you agree, you require that place.
Yeah, I mean, Judge, I think that in the non-Baker case, they said it was reckless. Because basically, and I think and I do think it's reckless. But I think we need to hear more about what Detective Stanford knew. What he knows now doesn't matter. I get that, it's irrelevant, right? But what he knew the day he testified is very relevant. And you know, I can think of one witness, an attorney, who specifically said, I think he's had a psychotic break. And so to say that your investigation so far is showing us in the same mind, yes, I think there's at least enough there, Judge, for let me put the witness up there and ask. And then coming to our additional items that I think are also of concern, there's a question. I cited those, Judge, and those are additional items. The court doesn't want me to go about each instance. I'll just say that is the sort of thing that I think we need to know from Detective Stanford. If you knew these things, why did you answer this misleading way? And I think it's right. I said, thanks. And I don't have to, we need to hear you find out those rights. Unless the court wants to certainly take it under submission and dismiss without an evidentiary hearing, we would request that as well, Judge. But if not, we would ask it to put on. Sure. Thank you.
Thank you, Your Honor. Your Honor, the Commonwealth is at the position that we certainly acted in compliance with the rules of criminal procedure here, the rules specifically that were cited by the defense counsel. And we would ask that the court to dismiss the motion, to deny the motion to dismiss the indictment if it's wholly without merit. Your Honor, here, counsel is correct in citing Rule 5.06 that we could have unilaterally issued a grand jury subpoena to obtain these mental health records. That is a power that the Commonwealth does have. However, in taking an extra step in the interest of transparency, if the grand jury is an independent investigative body, and to ensure that there was no argument that we were usurping our grand jury subpoena power, We appeared before the grand jury on October 17th of 2024 without a witness, specifically to ask for these mental health records from two different providers for the defendant. We appeared at that time, there was no witness, there was no testimony presented. Counsel, again, is correct that pursuant to Rule 5.16, had testimony been presented at that time, it should have been recorded and would have been required to be recorded. Myself and Mr. Steele. Only the special prosecutors were present. No witnesses appeared on behalf of the Commonwealth. And so, Your Honor, the rule is clear. It requires testimony in order for there to be a requirement for recording. And there was no testimony presented at this time. And I think that is apparent. The court now has a copy of the actual recording of the grand jury proceeding for the testimony that was presented on December 21st, the only time the testimony was presented. And I believe a review of that testimony, some of which is referenced in the Commonwealth response that has been filed, will show, based upon the questions that were lodged by the grand jurors, the only thing that was requested at that time were this grand jury's opinions for those medical records. I think that's reflected in the context of the recording of the grand jury presentation.
You will also represent the request made.
I'm sorry,
You will also representing the request made.
yes, Your Honor.
There's no further commentary or anything.
No, Your Honor. Specifically request for those grand jury records, for the mental health records pertaining to the defendant, one from ARH and one for Leslie County Detention Center.
Just a point of clarification, I understand your question. As you can imagine, nobody in the grand jury would need to be told what case this was, or anything regarding that. So when we went in and we said, we're the special prosecutors in this case, we're here just simply to get grand jury skin for mental health records. They began asking questions, of which we did not have an answer to. We never answered any subsequent questions other than that. That's something we're looking at. That's part of the investigation. Those matters get printed and explained. There was never, of course, at this point, I'm preliminary hearing ordinance had, the video was already out. Other videos had been released. There was nothing we added at all to or any conversation regarding the case other than the investigation involving the that would have been it.
And Your Honor, additionally, we asked the grand jury to memorialize what was being requested and as far as the grand jury's opinion in writing, which was authored by one of the members of the grand jury and signed off on by the foreperson. The verbiage of that is reflected in the response as well, but specifically which records they were requesting and authorizing via grand jury subpoena. So those grand jury subpoenas were issued, the records were received, those records were then promptly provided to counsel for the defendant on December 4th of 2024 in the very first discovery document. So in compliance with our discovery obligations, Your Honor. So the Commonwealth believes it's clear, based upon the rules of criminal procedure, that we acted in compliance with those rules. We have additional arguments as far as the Jackson case. However, the Commonwealth does not believe it's necessary to delve into those at this time unless the court would like to hear them as they're reflected in the response. All right, thank you, Your Honor. So clearly, we do not believe any evidentiary hearing is required with respect to the argument that there was no recording made. That is apparent from the recording that the court already has. So no evidentiary hearing is required. As far as the second argument, turning to the actual content of what transpired and what Detective Stanford testified to and questions that were asked during his testimony to grand jury in November. Your Honor, I think defense counsel is conflating the role of a grand jury proceeding with the role of a criminal trial. It is very clear under the law that they are distinctly different proceedings. The grand jury is an investigative body. The Commonwealth has no obligation, as is reflected in an abundance of case law, to come in, to present exculpatory evidence, and to attempt to mount a defense for the defendant. That is not the Commonwealth's obligation. Additionally, the rules of evidence, particularly Rule 1101, does not says that the rules of evidence do not apply to grand jury proceedings. So, hearsay, opinion testimony, the right to remain silent, all of those things are not required to be adhered to at a grand jury proceeding. If they were, our grand jury proceedings would be the same length as a criminal trial, but it's not 10. Exactly, Your Honor. And so I believe counsel's arguments are confusing the two, the purposes of the two. You know, hearsay is presented routinely at grand jury. Opinion testimony, such as Detective Stanford's testimony, is presented routinely at grand jury. These are commonplace and they are permitted under the law. Absolutely, Your Honor. Certainly. And Your Honor, the Commonwealth is of the position that an evidentiary hearing is not required. Everything that transpires in testimony was presented to the grand jury in November is captured on that grand jury report. The Commonwealth cannot conceive of a reason to haul witnesses in to talk about what transpired on that recording, Your Honor. And so we do not believe that evidentiary hearing is required. Or is required, sorry, Your Honor. So, Your Honor, again, the court has that grand jury recording. We would ask that it be filed under seal as a grand jury proceeding. And we would ask the court to deny the defendant's motion to dismiss the indictment in its entirety without any necessity of an evidentiary hearing. And we would rely
So, I mean, I didn't put anything, I said it to the meeting judge. I understand we're talking about rules evidence. The reason I cited to the issues where there were things that normally wouldn't come in is because there were instances throughout the grand jury when the witness was about to answer something the grand jury asked for, and it was shut down. I was contrasting. Oh, I get that, Judge, but my point is this, if you put that into context with what they led testify, and I think ultimately, Judge, would put on that evidence will show you that this grand jury was mistaken. I mean, the state law, to be honest with you, the state alone, a greater opinion on insanity than this. In terms of, I give you on being an expert judge, but if you say it, you miss it. And then, so I'm not asking you to look at whether this thing should be inadmissible or not. That, I'm not at all. My point is that the grand jury is an investigative law. And they don't get to dictate what they hear if the grand jury's asking for additional stuff. So in other words, if they ask a question and it's germane, I'm talking about relevance, but it's germane, it's their grand jury. It's not common jury. They're the investigative law. And so the reason I cited the things that I thought should have came in is that in contrast with other things that I think they asked, never got told those questions would be coming. And that's why I asked for the.
I believe I should talk about 2,000 cases being presented for grand jury.
Sure.
I would listen to the recording.
In your, if the Commonwealth, thank you. I would like to make a distinction. The Baker case, we're talking about misleading techniques and an aluminum back versus a wooden stick. I would think there's nothing even alleged in the pleading, even if you take everything in the pleading that's been said today by the defense as true, it would be tantamount or even close to that, Your Honor. You know, as far as the mental state of the defendant at the time of the offense, that wasn't even an issue at the juncture of the grand jury. That hasn't been raised since by defense counsel. So, Your Honor, again, I don't believe that those arguments are well taken. We would ask them to deny their motion.
Right, I'll be more than, well, if I need to hold on to the hearing, if not, I will hopefully be studying that. I would like to see the last one, once I was proceeding with the conclusion of the hearing, and then take a copy of the closing, which would be the first.
For sure.
All right, next one.
I can't.
Yes, Your Honor. And yet, Gary Bartley for Sean Stines, Judge. And we filed our motion for the court to, it's been back quite a ways now that we filed that.
I've been trying to find some app to remove that background noise, but nothing is able to do it like live. They're all like a pre-recorded thing, so. Oh.
But we did ask the court to kind of hold
I
off.
have a little that's particular thing.
I think pursuant to criminal rule 440, I believe it is, we're entitled to an evidentiary hearing. I think it's going to be necessary for us to bring
Look at that.
witnesses. We had some witnesses lined up. And I think it'll be necessary
fixed
for the court to hear that evidence
I
and
didn't
make
do
its
that.
findings on whether there are several factors by statute that the court has to consider when determining whether the bond is appropriate. And there's an added level here, and I anticipate the Commonwealth will argue that Mr. Stines is not entitled to bond because of the way that this case is charged. Okay, so in that situation, Judge, they're going to have to put on proof. It's actually their burden to show the court if that is in fact what they argue, and I don't know, I'm just anticipating, but it is their burden if they're trying to preclude him from bond at all to put on proof that guilt is evident or the proof is essentially, there's great evidence of the proof, right? And so I can anticipate what those arguments are going to be. I can anticipate all of that, Judge. But I think given what we know, and again, without putting any of that on the record today, given what we know now, I think we'll have an argument on bond.
What would be your proposed bond, like circumstances?
Absolutely. And given what his income is, given what he's able to post, and I think that's what the statute requires the court to look at is what he could reasonably post. We would
Public
propose.
safety is a factor also.
Absolutely. There are several factors, Judge. I just think that in terms of what the amount would be, the court has to look at what he could reasonably post if he is in fact entitled to a bond. So our proposal, Judge, would be $50,000 cash for property with any non-financial conditions that the court would require, and the court could set a host of non-financial conditions, Judge, as you well know. However, I think that given Mr. Stines, and again, without waiving any of our,
What are they doing?
any of our ability to put on proof, I would ask the court to take a look at the
What are
fact
they
that
doing?
he is, the lowest possible risk level that one human can be in terms
I'm
of his
almost stop it
pretrial
for a second.
service.
Pretrial risk assessment, of all candor to all parties is something that, as a prosecutor, now as a judge, I don't have the utmost faith in it.
I understand, Your Honor, but it is also something that the statutes require the
Understood.
court to take a look at. And there has to be some other evidence that the Commonwealth can put on.
Some other
or
evidence.
Some other evidence.
Some other
in front of the
evidence.
court that he would be a flight risk, that he would not return to court, that he would be a danger to himself and the community. And again, I think that's why it's important for us to be able to put on proof and to be able to put on some of the stuff that's in that basic piece of report. I think that when we are able to show the court
It's a very-
what's in there versus, all the other things, I just don't think there's anything to show.
Very different shade of pink, magenta, lilac. No, it's not pink, but it's not purple. Oh, are they? Are they in the background?
That he's a flight risk. There's nothing to convince the court that he would be a danger to himself or others. And I understand why we're here, judges. I get that. But the courts have said consistently, and it's, I believe, the Abraham case.
And her contouring. Have a look at her eyes. Yeah, that's a little bit extreme. I'm being very picky today, aren't I? I can see the white, where she's put the white under her eyes and on the nose and then above the eyebrows. That's contouring. But that's big contour.
That you have to look at something other than the charge.
I
Has to be
understand.
something else, right? We can't just look at the charge defense.
But that can be factored in.
Okay, and on this side.
So, Judge, I think we're going to need that testimony and we're going to need that report. I would ask the court, again, without waiving anything, I would ask the court to consider setting.
Is that wife and daughter in that front row there?
Bond for, of course, can do that at any time. And that would be our requested bond, 50,000 cash or property. If the court wants to hear just a little bit about what we would put on, again, Mr. Stines is a member of this community for his entire life, born and raised here. He has a great deal of family support through all of this, as the court can see. He has a wife and daughter that he can still go home to today. He was a member of law enforcement for basically his entire adult life, up until the point of his arrest. Is a respected member of law enforcement, a respected member of the community, and frankly, Judge, everything we've learned about him since then corroborates that. And I would have testimony to that. There's no evidence that he would be a flight risk. No, he has no failure to appear on his record. He has no, property in the Bahamas that he can run off to. There's nothing. This is a man with a great respect for the law, and he's built his life around upholding the law and serving his community. Just there's nothing that I've seen that anyone's seen. And frankly, when we put on our proof of the court will see, there's nothing to say that he would not return to court. There's nothing to say that he would commit another offense. There's nothing to say that everything in this pretrial services report, respectfully to the court, is not correct. That he's a low 0-0 risk, just because this is a man who, again, there's, with all due respect to the court and to everything that, for the reason why we're here, the court does have to look at something other than the offense charged. I know it's a good one.
I understand that, but this, you would have to admit, is a unique fact circumstance.
Absolutely.
This is not a whodunit. The actions are very
No.
evident. What the end result of that is, that's the purpose of the cases we're proceeding. on.
Yeah.
So, all right, I understand your argument. Still,
Your Honor, if I may respond, she went through a lot of the statutes. Unfortunately, she forgot the Kentucky Constitution, section 16 says that all people are entitled to bail unless there's a capital offense. And the word she was looking for is when proof is evident, the presumption is great. There's just recently in 2024, a Kentucky Supreme Court case on this issue. It was out of Breckenridge County, if I'm not mistaken. The site on that is 2024 WL 298-2769. That is a case in which, much like we are sitting here today, the defendant was charged with capital offenses. The Commonwealth made a statement on the record they were not seeking death in that case. That statement made at that point in time, the judge set a bond over the Commonwealth's objection. The Commonwealth then filed appeal on that issue. The Supreme Court come back and did the exact analysis they're asking you to do. And basically, what he did in the community, what he did is irrelevant. The only thing that's relevant is, in fact, the charges themselves. And the Supreme Court said, if you are charged with a capital offense, you are not entitled to bail. And they overturned a circuit judge and sent it back to nobody. So there's a case already up at the Supreme Court issued last year. I gave you the citation for it. And the case number on that is, or the case name on that one, I don't think I gave you that, is Commonwealth versus Rodney Jones. And Judge, there's enough in the record already. You can take judicial notice. That's why the Commonwealth introduced the video here at the preliminary hearing.
Right.
It's very clear what happens in the preliminary hearing. They were counsel of record at the time, so there's not an issue. They did cross-examination of that. The record is very clear. The video is very clear. And Mr. Stines, in fact, took the life of Mr. Mullins. So that's all required. Even under the case law, state constitution, he is not entitled to bail.
Your Honor, if I could briefly respond. I do have a piece of case law I can cite here, Judge. It's Burton v. Commonwealth. It is an older case. It's 212 Southwest 2nd, 2010, Judge. It does show that the court can take into consideration the mental state of the defendant when setting bond in a capital case. So if this case was basically where evidence introduced in a hearing on motion for bail showed defendant to not be guilty of murder, but only voluntary manslaughter, in the event that the jury did not find self-defense, the proof of guilt was not evident, nor the presumption, right? So I think the court can take that mens rea into consideration and that mental health evidence into consideration, which is again why we want to be able to introduce that.
Thank you. In response.
Judge, I believe the case law I cited speaks right to the issue.
All right. All right, as with the other issue, like I said, here's what I'm gonna do. Mr. Steele, you said that you all would file a written response on the KCBC evaluation within 10 days. So
On a motion to unseal?
Yeah.
Yes, Your Honor.
why don't we do this? If anybody wishes to submit case law or supplement anything in regards to pleadings on all three of these matters, if both sides will do it simultaneously within 10 days.
Within 10 days, Your
Within
Honor?
10 days.
Yes, sir.
Yes, sir.
And then that'll give us time. I'm going to try to expedite rulings on this, and then we can start looking realistically more at setting the next hearing. And I think once we get these initial matters addressed, we can then start realistically looking at potential trial date
Yes, sir.
for all parties. So
One thing, Judge,
Sure.
can we do 10 days from Monday since today's kind of
10
short next week?
days from- why don't we do this? 2 weeks from today.
Yes, Your Honor.
That work?
Yes, Your Honor.
Or you want the weekend and add one more Monday?
I'd
Mostly
rather,
your motions.
under promise and over deliver, Your Honor.
All right, why don't we do this? And both sides will have till Tuesday, September 2nd.
Yes, Your Honor.
That should give everybody plenty of time.
Thank you, sir.
All right, and then after I get those pleadings, I will notify the parties and we'll get a more realistic timeline on when we'll set the next hearing.
Yes,
All
sir.
right, other than these three matters, I know we have one matter that we'll have to address ex parte that we'll talk about in just a minute. And for purposes of record, the Commonwealth, you've been given notice that they filed for an ex parte hearing in regards to funding.
Yes, sir.
And you're aware that the court will address that at the conclusion.
Absolutely, Judge. And just to make the parties aware of talk those in chambers, we are looking for an expert on this issue. And
Sure.
and there's plenty of chance we have to go through depending on what those come back as for an expert also. So we made the council aware of that also.
All right, thank you, Mr. Steele. Anything else we need to address today before we adjourn before the ex parte hearing?
Nothing
There you
more.
go.
All right, ladies and gentlemen, pursuant to the rules, what we're about ready to have an ex parte hearing in regards to one matter. I'm going to be in recess for about 5 minutes. It's a good time for the courtroom to be clear. Obviously, defense counsel and the defendant will be able to remain for that part of the hearing.
Yes, sir. Thank you, Your Honor. We'd like to.
What's that?
Yes, Your Honor. We want to talk to him for just a minute.
Yeah, absolutely.
Take care.
All right.
Thank you.
So what did they just book in for the 2nd of September? Or was that just their deadline before the next hearing? Oh, I can fast forward. Oh, I'm sorry, Judge, that's more than a 5-minute recess. That surely hasn't finished. No. Oh. Now where are we? The fuck's going on here? So, what? What the fuck? That's it. Really? I can barely understand his voice.
That we'll talk about in just a minute. And for purposes of record,
We want to do the introduce that.
thank you. In response.
Judge, I believe the case I cited speaks right to the issue.
All right. All right, as with the other issue, like I said, here's what I'm gonna do. Mr. Steele, you said that you all would file a written response on the KCPC evaluation within 10 days. So,
On a motion to unseal?
yeah,
Yes, Your Honor.
why don't we do this? If anybody wishes to submit case law or supplement anything in regards to the pleadings on all three of these matters, if both sides will do it simultaneously within 10 days.
Within 10 days, Your
Within
Honor?
10 days.
Yes, Your Honor.
Yes, sir.
And then that'll give us time. I'm gonna try and expedite rulings on this, and then we can start looking realistically more at setting a next hearing. And I think once we get these initial matters addressed, we can then start realistically looking at potential trial date
Yes, Your Honor.
for all parties. So
One thing,
Sure.
Judge, can we do 10 days from Monday, since today's kind of shot next
10
week?
days from, why don't we do this? 2 weeks from today.
Yes, Your Honor.
That work?
Yes, Your Honor.
Yes, sir.
Or you want the weekend and add one more Monday?
I'd
Mostly
rather,
your motions.
I'd rather, under promise and over deliver, Your Honor.
All right, why don't we do this? And both sides will have till Tuesday, September 2nd.
Yes, Your Honor.
That should give everybody plenty of time.
Thank you, sir.
All right, and then after I get those pleadings, I will notify the parties and we'll get a more realistic timeline on when we'll set the next hearing.
Yes,
All
Your Honor.
right, other than these three matters, I know we have one matter that we'll have to address ex parte that we'll talk about in just a minute. And for purposes of record, the Commonwealth, you've been given notice that they filed for an ex parte hearing in regards to funding.
Yes, Your Honor.
All right, and you're aware that the court will address that at the conclusion.
Absolutely, Judge. And just to make the parties aware of talk those in chambers, we are looking for an expert on this issue. And
Sure.
and there's plenty channels we have to go through depending on what those come back as for an expert also. So we made the council aware of that also.
All right, thank you, Mr. Steele. Anything else we need to address today before we adjourn before the ex parte hearing?
Nothing
There you
more
go.
to come.
I do. All right, ladies and gentlemen, pursuant to the rules, what we're about ready to have an ex parte hearing in regards to one matter. I'm going to be in recess for about 5 minutes to give time for the courtroom to be.
All right. That's it. So. What's happened is he's given them until the 2nd to get all of their pleadings in so that he can rule on them and set the next ex parte hearing. And at that's when he'll make his rulings and set hopefully a trial date. That's what I'm going to do. Everything has to be in by the 2nd so that he can then make rulings on it and move ahead. I'm so glad I stayed up for that. I'm actually going to do a quick video now, but it'll be pre-recorded on the instructions for this mock trial. Because there'll be like a download pack that you guys will get, which will have all of the roles, so the judge, the defense attorney, the prosecutor, all of their biography details, how old they are, blah blah blah. So a bit of a history. Oh, stop! I'll get to that in a second. And it gives you, I'll put in it like the all the crime scene photos and the autopsy report and all that sort of information so that you can familiarize yourself with it. And it's also, you have to use certain prompts in chat to be interactive to make the decisions. Plus, you also have to pick your role. So I'm setting up a pack, and I will do a video, put it up in the next, hopefully, hour. And then in the description box will be like a downloadable file, basically, with all your information on it. Because I need to have at least 5 people commit to it to be able to run it. So, yeah, cool. And you didn't have to do that, my love. Thank you. Hang on, it's coming.
Shout out to the person that just gave us a super chat. This community is just the best. Love you all the different.
Don't be spending all your birthday money on me. Thank you. You don't need to do that, sweetheart. All right. Well, you go and put a nice cold, wet face washer on your eyes and your forehead, and put yourself in a dark room. Yeah. Oh, you poor bugger. Any Valium? That'll help. Yeah, I don't know what else to suggest for you, Dylan. That's the only part of me that doesn't hurt. Think, fuck. I might get confused a lot, but yeah. Alrighty, my lovelies. Bugger. Yes, look out for the info video, which will be out in the next hour or so, and join us for the interactive mock trial. Sounds like it's going to be fun. All right. Mwah. Don't be good at it, and hasta la vista, bitches. Bye.
Hey there, thanks for stopping in. We hope you will join us again. We all look forward to next time. We get to talk about true crime. Clues. Justice served in an honest fight. True crime tales till the verdict's right. Solving more than just trivial quests, with sentences rule and the defense rests. Our true crime family is great. All types of topics we debate. Smash that like and ring that bell. Hit subscribe, you might as well.